And now I think I should step down from the chair and give the floor as the chair of the first panel to Ms. Ning Zhao. So please, Ning, you have the floor, and now all the work is upon you. Thank you.
Okay. Thank you very much for these interesting and inspiring introductory words. Indeed, today's conference is one of the promotional activities, or to say, responding to the encouragement of the three secretariats to promote the use of the legal guide. So at this panel, three topics will be presented: the importance and the new development in terms of choice law and choice forum, the interfaces of the CISG, the UNIDROIT Principles, and the HCCH Principles, and the application of the UNIDROIT Principles in practice. In fact, these elements have been addressed or touched upon in one way or the other in the legal guide. Thus, for the discussion today, I would like to set the scene by briefly describing the structure of the legal guide and the methodology adopted. So the legal guide contains 5 chapters. The first 2 provides information on the origin, purpose, scope, and the approach of the legal guide. Chapter 3 deals with the issue of identifying the law applicable to international commercial contracts. Here, reference is made to the HCCH Principles. So chapter 4 talks about the uniform law of international trade, international sales, discussing in particular the provisions of the CISG, of the Limitation Convention, and of the UNIDROIT Principles, as well as their interaction. The last chapter summarizes recurring legal issues that arise frequently in connection with sales contracts and how they are addressed in uniform law instruments, such as the use of electronic means, distribution contract, intellectual property issues, counter trade, etc. So while the purpose of the guide is to provide an introduction to and a brief summary of these key instruments of the organization, the 3 organizations, emphasis is not only placed on their complementary nature, but also on the use of regional or supranational instruments, such as the EU Rome I Regulation, the Mexico Convention, OHADA Uniform Act on General Commercial Law, OAS Guide, etc. In the meantime, also on the model contracts based on uniform texts, such as ICC Model, International Sales Contract, International Trade Center Guidance Text, IBA Cross-Border Transactions, Draft Guide for International Sales Contracts. After setting the scenes, now it's my pleasure to introduce you the eminent speakers at this panel. So following the order of the speaking, Professor Stefan Vogenauer, Professor Neil Cohen, and Professor Michael Joachim Bonell. So in the interest of time, I will briefly introduce them to you. Professor Vogenauer is director at the Max Planck Institute for European Legal History and chair of Max Planck Law. He works mostly in the areas of European legal history, comparative law, and transnational private law. He is editor of commentary on the UNIDROIT Principles of International Commercial Contracts, so 2nd edition published in 2015. As we just heard, Professor Vogenauer is one of the 5 experts drafted the legal guide. Professor Cohen is professor at the Brooklyn Law School. He is a key participant in major domestic reform projects. At the international level, Professor Cohen has served as a member of the U.S. delegation to UNCITRAL for its work on harmonizing and modernizing the law of secured credits. He was also a member of the working group on the HCCH Principles. He was a member of the working group at UNIDROIT that prepared the latest editions of the UNIDROIT Principles. So Professor Cohen is also one of the authors of the legal guide. Professor Bonell is Professor Emeritus of the University of Rome I and consultant at UNIDROIT. He is membre titulaire of the International Academy of Comparative Law. He acted as the chairman of the working group for the preparation of all 4 editions of the UNIDROIT Principles. He was delegate at the 1980 Diplomatic Conference for the adoption of the CISG. He also represented UNIDROIT at the discussions of the HCCH Principles. He is editor-in-chief of the database UNILEX of the UNIDROIT Principles and the CISG. So, professors, we look forward to hearing fascinating views from you at this panel. So, without further ado, I give the floor to Professor Stefan Vogenauer. Thank you.
Thank you. Thank you very much, Mrs. Chair. It's very unusual for me to speak to the camera. I feel like an important politician, but I'm delighted to be present at this conference today, although I'm slightly saddened not to be able to meet my co-panelists in person, but I still hope we'll have a very good discussion later on. Now, the title that has been assigned to me by the conference organizers is Choice of Contract Law and Choice of Forum, New Developments with Regard to Regulatory Competition. And I suppose they've given that theme to me, and they've given it to me at the beginning of the conference, because the starting point really here is a world without uniform law, which in this group is of course a terrible and uncivilized world, with national laws just coexisting side by side, a world without the CISG, a world without the UNIDROIT Principles, without the Hague Principles, and without the Tripartite Legal Guide. Now, the title of this contribution takes up an article that I published in 2013 in the European Review of Private Law. And the purpose of that article was to challenge a claim made mostly by law and economics people that there is such a thing as regulatory competition in the European Union with regard to the areas of contract law and civil litigation. And those of you who are perhaps a little bit foreign to that jargon, let me just explain briefly what the theory of regulatory competition is about. It is a theory that has a descriptive and a normative dimension. Now, the descriptive dimension holds that there is an assumption that parties that make cross-border contracts make rational choices of law and rational choices of forum, and they make these choices based on the inherent quality of the contract law and the court systems in question. The other part of the theory holds that national lawmakers compete for the business of these users of contract laws and court systems. And this means that national lawmakers constantly reform their contract laws and their dispute resolution mechanisms with the purpose of attracting this business. Now, that's the descriptive part of the theory. And the normative part, as always in law and economics, is that competition is a good thing. And it is assumed that because national lawmakers gradually improve the quality of their contract laws and their dispute regulation mechanisms in order to keep up with the demand of these users, ultimately this regulatory competition leads to better contract laws and better court systems internationally. The article that I wrote in 2013 tried to test these assumptions by looking at the empirical evidence on the choices of contract laws and the choices of forum that parties in cross-border contracts in Europe actually make, and also looking at the reasons why these choices are made. And secondly, the empirical evidence of lawmakers actually competing for business by producing ever increasingly attractive rules for international users of their contract laws and their court systems. The conclusion that I had in 2013 was a little bit disappointing. I could not find evidence of meaningful regulatory competition in the areas concerned. On what economists would call the demand side, the choices of law and the choice that parties actually make. What I found is that these choices are not made with regard to the inherent quality of the contract law in question or the court system, but that there are issues like prestige, familiarity, perceptions of neutrality, and indeed language that are, of course, much more important. Also on what the economists would call the supply side, namely what the lawmakers actually do, I found precious little evidence of lawmakers improving their laws in order to attract this kind of business. There was a lot of talking the talk about making national contract laws and national court systems more competitive, but I couldn't see much in terms of active improvement of the laws in these areas. And this was particularly marked once you juxtaposed it to how arbitral institutions constantly reform their rules, make them more user-friendly, adapt them to attract business. Now, the question is, of course, has the landscape changed? Is this different in 2020? What about the more recent developments? And I think there are some interesting recent developments, and we've moved to a landscape that is perhaps more competitive, but still not as competitive as economists would tell us. On the demand side, I think there's still relatively little evidence that parties look at the substantive quality of the contract laws they're choosing. And perhaps we'll hear a little bit more about this once Joachim later on speaks about the UNIDROIT Principles, who are certainly, as most people in this room would agree, a superb contract law regime, which is still relatively rarely chosen. But where we can see changes is really in the attitudes of lawmakers. We can see some evidence that European lawmakers, at least, engage in more competitive conduct. A good example would be the French contract law reform of 2016 that explicitly listed the attractiveness of French law as one of the reasons for changing the law, the attractiveness for foreign users. However, on closer inspection, much of this is only rhetoric, because many of those rules that were newly inserted arguably make French contract law less predictable and perhaps less attractive for commercial parties from abroad. The introduction of the doctrine of imprévision, the policing of standard terms, and also the policing of other terms as to their substance. And of course, one major obstacle to true competition in the area of substantive contract law is the continuing existence of Article 3, Paragraph 1 of the Rome Regulation, which in a way stifles true competition in that it does not allow national courts to acknowledge choices of transnational contract law instruments like the CISG and the UNIDROIT Principles. And perhaps then later on, Neil is going to talk about the perspective of the Hague Principles that aim, of course, to change this. If we turn to court systems, I think this is a better example where we can see that national legislators are in a slightly more competitive spirit of mind, because what we can see across the board is the establishment of international commercial courts with a view to attracting international cases. We see this in France, in Italy, in the Netherlands, in Germany, and of course in many countries outside Europe. We find items like relaxation of language requirements, the introduction of more efficient and speedy procedures, the admission of electronic filings, of electronic transcripts, and so on. Courtroom infrastructure is being improved. Specialized judges are being appointed. And the idea is really to create for international commercial contracts a court system that can perhaps also compete with arbitral institutions. Again, however, I would argue that many of these changes are slightly half-hearted and perhaps cosmetic, sometimes contradictory, sometimes self-defeating. Often the legislator is not willing to go the last mile. Just a good example would be the reform in Germany, where you can have hearings in the English language, but if you wish to appeal to the federal court, your hearing will have to be held in German. You also can see fractured jurisdictions. There was a very interesting article by Marco Tosello recently on the special commercial courts with jurisdiction over claims against foreign defendants in Italy, where he comes to the conclusion, quote, that the result of this confusing overlap of legislative interventions is a questionable patchwork of legal provisions, often difficult to coordinate and interpret. So perhaps arguably, this hasn't improved things, but rather added to legal certainty. And the disappointing state of affairs, I think, becomes much clearer if one looks beyond Europe and looks at what Singapore has done with its International Commercial Court in a highly professional way, an extremely efficient machinery, appointing foreign judges, and throwing tons of resources at a new court that is fully integrated into the judicial hierarchy in Singapore. So the conclusion of this very short intervention is that the rhetoric of regulatory competition has certainly increased over the past few years. There's also limited evidence of competitive actions by national lawmakers. However, these tend to stop halfway and are not really followed through. So perhaps I'll be able to speak again in 7 years' time and give you a new update. Thank you very much.
Thank you, Stefan. Thank you for your interesting presentation and for sharing the new development in with regard to the regulatory competition in both sides of the contract law and the court system. So now I give the floor to Professor Cohen. Thank you.
Well, hello, everybody, and good afternoon, or good morning, or good evening, depending on where you are. It's a pleasure to be here today at the to promote this new tripartite instrument, and to as part of promoting that new tripartite instrument, to remind everyone of the major instruments that it discusses. The task to which I've been assigned is to discuss the HCCH Principles and their relationship to the CISG and the UNIDROIT Principles. Since the HCCH Principles are principles about choice of law rather than being substantive law themselves, one might think that they are the odd element in this mixture, but in fact, as those who have read through the legal guide have seen, they in fact play a major role in the legal framework created by these three instruments. And so what I will be doing today is to talk about that role. In the legal guide itself, it is first discussed as a general matter and then in increasing levels of detail. As those who are in attendance here are well aware, the three instruments that I'll be talking about, the Hague Principles, the CISG, and the UNIDROIT Principles, are really three very different types of instruments. The CISG is an international convention that provides substantive law for the international sale of goods. Again, it's well known to all. And not only does it contain those substantive rules, but it contains the rules that determine its applicability. And the most common route by which the CISG becomes applicable to a particular contract is in Article 1.1a, which indicates that the CISG applies to contracts for the sale of goods between parties whose places of business are in different states, so long as those states are both contracting states. And so here we have, again, a convention that applies by its own force by rules that are stated in that convention. The UNIDROIT Principles, on the other hand, as their name suggests, they are principles. It's a set of soft law principles promulgated by UNIDROIT in a series of publications over 2 decades under the leadership of Professor Bonell, from whom we'll hear next. And while the principles are soft law, they are indeed principles. They are not legal mandates, but they have been very influential, and they can become the governing law of a contract through a number of routes, some of which I'll be discussing over the next few minutes. The HCCH principles, the Hague Principles on choice of law in international commercial contracts, are also soft law. They are indeed principles. They're not a convention or a mandatory set of rules, but their influence too is beginning to be felt. It's a relatively recent instrument in the slow-moving world of international law reform, but as we've heard already, their influence has been felt. They have been largely incorporated into the law of Paraguay. We heard earlier about Mozambique. The principles are being studied by the reporters for the new restatement of conflict of laws in the United States, and certainly it's being read around the world. And the Hague Principles address and largely promote the power of parties to choose the law governing their international commercial contracts. In this regard, they tackle many of the same issues that are tackled by the Rome I regulation and the Mexico Convention of the OAS. So what we're really talking about is, in this section of the panel then, is how does party choice determine the applicability of the CISG or the UNIDROIT Principles, because the heart of the Hague Principles is party autonomy. It is designed to promote and largely validate the choice of governing law by the parties to a transaction. Well, of course, the CISG applies by its own force when the parties to the contract are both in contracting states, but that's not the only route by which the CISG can apply. Article 11B of the CISG tells us that the convention also applies when the rules of private international law lead to application of the law of a contracting state. Even if both parties are not in contracting states, if the rules of private international law would lead to the law of a contracting state, 11B says that the CISG governs. So one effect that the Hague Principles can have is to validate the party's choice of the law of a contracting state, to the extent that Article 2 of the HCCH Principles tells us very directly a contract is governed by the law chosen by the parties in a state that adopts the HCCH Principles as its choice of law principles. The effect of this will be to validate the choice of parties to an international contract for the sale of goods to have their law governed by a contracting state, and as a result to have the convention apply. But there's an important limitation here, and that is that Article 95 of the CISG allows states to declare that they are not bound by Article 11B, and some major commercial states have in fact indicated pursuant to Article 95 that they are not bound by Article 11B. So if one of the parties or the possible forum will be one of those states that have made such a declaration, simply making a choice of law, that a contracting state is the governing law will not necessarily invoke the convention in a particular forum. Well, how else can party autonomy, the very simple rule of Article 2 of the HCCH principles, that the parties can choose the governing law, how else can the UNIDROIT principles or the CISG be made the governing law? Well, one way they can do it simply is to incorporate the CISG or the UNIDROIT principles into their contract by reference, by simply stating that the parties wish their contract to be governed by the CISG or the UNIDROIT principles. Again, that's not needed for the CISG if it applies by its own force, but if the parties aren't in contracting states and the rules of private international law do not point us to a contracting state, then the CISG by its terms doesn't get us there, but perhaps the parties could incorporate their terms by reference, and that might seem to work either for the CISG or for the UNIDROIT principles. But of course, there's a limit on how well that works. That only works to the extent that those rules incorporated by reference, whether they're the CISG rules or the UNIDROIT principles, the incorporation only works to the extent that the incorporated rules would not vary a rule of law of the state whose law governs the contract that cannot be varied by agreement. Every state has rules of contract law that are not subject to contrary agreement by the parties, and incorporating by reference a set of principles that would vary rules that cannot be varied would not be effective as a matter of incorporation by reference. As a result, that is a method to get many and most perhaps, but not necessarily all of the rules from the CISG or the Hague Principle, the UNIDROIT principles in becoming the governing rules of the contract. The third way to do it, and the most innovative way emerging from the HCCH principles, is to take note of Article 3 of the HCCH principles. And Article 3 tells us that the law chosen by the parties may be rules of law that are generally accepted on an international, supranational, or regional level as a neutral and balanced set of rules under the law, a neutral and balanced set of rules unless the law of the forum provides otherwise. Well, the key phrase here is rules of law. Again, the law chosen by the parties may be rules of law that are generally accepted as described before. That phrase, rules of law, as many here know, is really jargon. It's a phrase that's designed to describe something, that is not law in the traditional sense of law created by a sovereign and made applicable by the sovereign power of that state. Rather, rules of law are sometimes referred to as non-state law. Legal principles adopted, as Article 3 of the HCCH principle says, by international, supranational, or regional processes, and are a neutral and balanced set of rules. When that phrase was being crafted in The Hague, that phrase was being crafted partly, and in fact more than partly, significantly, to make sure that it captured things like the UNIDROIT principles, which are designed to be exactly what that description states, as well as the rules in the CISG themselves. So again, Article 3 allows the Article 3 of the Hague Principles gives a new a relatively novel and new type of freedom to the parties to choose not only the law of the state, but to choose these so-called rules of law. By doing that, by providing for that, the Hague Principles provide a new and important route by which either the UNIDROIT principles or the CISG, when it doesn't apply by its own force, can be the set of rules governing a international commercial contract. There's a difficulty here, of course, and that is that these are the Hague Principles. They are becoming influential, but in this regard, they have not yet felt their greatest potential of influence, except in the world of arbitration. It has been accepted in the world of international commercial arbitration that parties can indeed choose non-state law, can choose rules of law to govern their contract. But in judicial forums, this is still considered to be a novelty. I should point out, though, that the HCCH principles are already beginning to have some influence in this regard. Indeed, I've mentioned in the United States the project to do a new restatement of conflict of laws, and the latest draft of the chapter dealing with contracts suggests that the reporters are in fact favorable to the principle in Article 3 of the HCCH Principles, and the current draft suggests that the parties can indeed choose rules of law as the governing principle of their contract. Now, whether that will survive the vetting process, I don't know, but it's an example of Article 3 already having its influence. And indeed, UNIDROIT, in putting together model clauses for the application of the UNIDROIT principles, has indeed, in Model Clause 1, provided us all with sample language by which the UNIDROIT principles can be made the governing law of the contract through this process of choosing non-state law, of choosing rules of law. Well, are there any limits to party autonomy under the Hague Convention? Of course there are, and they are basically the standard limits. I said Hague Convention, of course it's the Hague Principles, and they're set out in Article 11 of the Hague Principles. The party autonomy given by Article 2 doesn't prevent the application of overriding mandatory principles of law of the forum or in some circumstances of another state. And similarly, it does not mandate the application of rules that would violate a fundamental policy or the public order of a state. So the standard limits are there, but it's unlikely that either the CISG or the UNIDROIT principles would be seen to run afoul of either of those. As a result, when one combines these three instruments, there are a number of ways they can be brought into force. Again, under the CISG, it can apply by its own force under Article 11A. They can apply when private international law rules lead to the law of a contracting state. And here, the HCCH principles can validate the choice of the contracting state. They can be incorporated by reference, but again, there are limits about the effectiveness of incorporation by reference. And the CISG, too, can be considered to be rules of law, because if the CISG would not apply by its force under Article 11A or 11B, it still is a very respected set of rules put together by an international organization that is seen by all as being neutral and balanced. And as a result, under Article 3 of the HCCH principles, it's possible for the parties to choose the rules of the CISG as rules of law when they wouldn't otherwise be governing. For the UNIDROIT principles, it's a similar analysis. First of all, of course, to the extent that any of the UNIDROIT principles, excuse me, to the extent that the UNIDROIT principles or the ones that the parties may care about in a particular context are incorporated in the substantive law of the state, then the parties, by choosing the law of that state, are getting the rules which may come from the UNIDROIT principles. And so the HCCH principles validate a choice of law of that state. Second, again, the UNIDROIT principles can be incorporated by reference. And finally, through those innovative Article 3 of the Hague Principles, the UNIDROIT Principles can be seen as rules of law that the parties choose, even though they are not the product of sovereigns, but nonetheless can be chosen by the parties to govern their contract. Again, this is something that is largely accepted in the world of international commercial arbitration. Its influence is only beginning to be felt, however, in judicial tribunals. So the interaction between these three instruments is complex, and without the Hague Principles, we wouldn't necessarily have as certain and predictable way to assure that these other two bodies of principles apply. As a result, when people read and reread the tripartite document, this may in fact explain why such a substantial portion of that document is devoted to choice of law issues, because a set of principles standing by itself or sitting on a bookshelf does not have effect unless one way or another they become the governing law of the transaction, and the Hague Principles can play a significant role in having these two wonderful substantive bodies of law become the governing law of a transaction. So that's a brief analysis of the interaction between the three instruments, and we're going to hear a lot more about one of the three of them in just a moment now from Professor Bonell.
Thank you, Neil. Thanks for the concise description of the three instruments and their applications and their interactions. Also, special thanks. Very happy to hear that the new development, the latest development at the new restatement of the conflict laws, and where the Article 3 of the Hague Principles is considered. So we are very happy to follow up the development. And now I give the floor to Professor Bonell. Thank you. Professor
Bonell, I believe you're on mute.
Yes, I'm so sorry. As usual, I'm a troublemaker, not yet accustomed to this kind of communication. And this, Valentina, you asked me to put on the light in my bag, but there is no light. And the weather outside is getting worse and worse, so you have to excuse my not too clear appearance. Perhaps it's an advantage. Ladies and gentlemen, the UNIDROIT Principles of International Commercial Contracts represent, in the words of the Secretary General, Professor Ignacio de Rado, an authentic flagship of UNIDROIT. Indeed, first published in 1994, and now in their fourth edition, they right from the outset met with great interest, both among academic circles and in practice. Now, concerning the actual use of the principles in the international dispute resolution practice, there are obviously no precise data available, but a sufficiently representative source of information is UNILEX, a database collecting decisions rendered worldwide and referring in one way or the other to the principles. And let me here just express my sincere appreciation to Eleonora Finazzi-Agro, the co-editor-in-chief of the principal section of UNILEX. Without her most valuable cooperation, UNILEX would not be the smart database that it is now. Of the 500 and more decisions so far collected in UNILEX, more than 1/3 apply the principles as the rules of law, here we are, governing the substance of the dispute. Admittedly, only in a few cases the principles were expressly chosen by the parties in their contract. More often, the parties agreed on their application after the commencement of the arbitral proceedings. In other cases, the parties agreed in their contract that the contract would be governed by the lex mercatoria or general principles of contract law or the like, and the arbitral tribunal applied the principles on the ground that they constitute a particularly authoritative expression of such principles and rules. And still in other cases, the principles were applied even in the absence of any indication by the parties. And in so doing, the arbitral tribunal relied on the relevant arbitration rules, such as, for instance, Article 21 of the ICC arbitration rules, according to which, absent an indication by the parties, quote, the arbitral tribunal shall apply the rules of law which it determines to be appropriate, end quote. Moreover, and finally, in a number of international investment arbitration awards, 10 of which were rendered under the exit arbitration rules, the principles were referred to, together with the domestic law of the hosting state, as an expression of international law. Yet apart from the application of the principles as lex contractus, in more than half of the decisions collected in UNILEX, they were used, by the way, not only by arbitral tribunals, but also by domestic courts, to interpret and supplement the domestic law governing the contract, thereby ensuring, to the largest possible extent, an interpretation of that domestic law consistent with internationally accepted standards. Yet, despite these quite significant achievements, I dare say, prompting, by the way, an expert of international uniform law like Henry Gabriel to describe them as one of the most successful soft law instruments, obviously the principles have here and there also met with criticism. And this not so much as to their content, but with respect to their material and territorial scope of application. Thus, it is said that the principles apply mainly, if not exclusively, to sales contracts, and therefore represent little more than a duplicate of the CISG. That the principles are known only in certain countries, while virtually unknown in the rest of the world. Finally, that the use of the principles as a means of interpreting the law governing the contract is limited to cases where this is the law of less developed legal systems, while such use is almost irrelevant in cases where the lex contractus is that of a highly developed legal system. At a closer look, however, these assertions are not at all convincing. Thus, with respect to the allegation that in practice the principles are applied mainly, if not exclusively, to sales contracts, just click in UNILEX on the search function type of contract involved, and you will see that in reality, the decisions collected concern no less than 51 different types of contracts. Admittedly, 1/3 of them, the decisions relate to sales contracts. But even more significantly, the total number of decisions relating to long-term contracts is even higher, precisely 142. And as to the nationality of the parties to the disputes, individuals or companies from 96 states of all 5 continents were involved, ranging from Algeria to the West Indies, including, apart from virtually all the European states, countries such as Australia, Brazil, Canada, China, India, Japan, and last but not least, the United States, mind you, with no less than 38 cases in which at least one of the parties was a US national. Finally, the use of the principles as a means of interpreting the domestic law governing the contract is far from being limited to cases where that law is that of a less developed legal system. In practice, equally, if not even more numerous, are the cases where the domestic law in question was that of a highly developed legal system, including the laws of Australia, Brazil, England, France, Italy, the Netherlands, Paraguay, Spain, Switzerland, and the state of New York. Even more importantly, there are decisions, including decisions of courts of second or last instance in England, Australia, New Zealand, Brazil, Quebec, referring to the principles as a source of inspiration for revisiting the current law in their countries. All in all, they are, say, undoubtedly a quite revealing picture of the material and territorial scope of application of the principles in practice. And yet, notwithstanding the well-known deficiencies of the traditional state law-centered conflict of law approach, more than 90% of the cross-border transactions continue to be subject to national laws. Why? Well, the answer is at bottom very simple and quite sobering. The principal reason is the inherent conservatism coupled with a good deal of provincialism of the legal profession. The legal education of the vast majority of lawyers is even today, let alone in the past, focused on one legal system, that is to say, that of their own country, with little, if any, consideration for foreign laws, let alone for soft law instruments such as the UNIDROIT Principles. No wonder that when assisting their clients in cross-border transactions, most lawyers will advise them to insist, if their bargaining power is sufficient, on the application of their own national law, or otherwise to opt for the domestic law of a third country, with little, if any, regard, we have heard this also from Stefan today, with little, if any, regard to their intrinsic merits as compared to other possible alternatives, not to mention what is, by the way, very often completely neglected, their compatibility with the terms of the individual contract. How could this situation be improved? The answer is quite simple: by making the principles better known in practice. Yet this is easy to say, but difficult to achieve. Fortunately enough, however, recently there have been taken some important steps in that direction. First, the endorsement of the principle by UNCITRAL, commending their use for their intended purposes. Second, the adoption of the Hague Principles in choice of law. As we have heard also today from Neil, in the comments, they expressly mention the principles as an example of rules of law capable of being chosen as the governing law in lieu of a particular domestic law. And third, the preparation by UNIDROIT of model clauses by which parties may indicate how they wish the principles to be used during performance of their contract or in case of dispute. Indeed, I would stress this, a remarkable example of synergy between the three most important international uniform law organizations. Yet before concluding, let me just mention other significant initiatives recently taken by the two leading international associations of lawyers. Thus, at the beginning of this year, the International Bar Association posted on its website a volume on perspectives in practice of cases relating to the principles, providing over 250 summaries of cases relating to the principles assembled by some 51 specialized practitioners from 28 countries. And the printed version thereof has been published by the International Law Institute in Washington. Moreover, just 2 months ago, the Union Internationale des Avocats adopted a resolution recommending, quote, consideration of the UNIDROIT principles as an important option by international lawyers and clients, end quote. These, Madam Chair, were very succinct remarks on my part on a subject which would deserve much more attention, but your ruling was very clear. Keep your presentation within 10 minutes at the most, so as to leave room for discussion. I would be delighted to answer any question you'd like to ask. Thank you so much.
Thank you so much, Joachim. Thank you for your interesting presentation. Actually, I'm very impressed by the work of the UNILEX with a great number of cases you have collected. Well done. I'm also very happy to hear that there's a wide use of the UNIDROIT principles. Of course, indeed, as you mentioned, that there are still potentials, right? There are still work to be done to promote a wider, even wider use of the principles. Of course, not only principles, we need to work together to promote the CISG and to the application of the Hague principles. Altogether, that's also the purpose we are here today, right? So thank you very much for the three distinguished speakers for your presentation. So now I give the floor to any question you may have for the audience, for the participants. So the floor is open. I have sent a message to everyone. If you want to raise hand or if you want to put your questions at the Q&A section, it's all fine. Okay. While waiting for the questions to come in, maybe I just use my privilege as the chair to raise a question to Neil and to Joachim. Of course, you know, for me, having the privilege to work with the 5 authors and the colleagues with the other 2 secretariats, I myself have learned a lot, you know, throughout the whole project. So my question now is regarding the Article 3 of the HCCH Principles that we have talked about, we have mentioned in the legal guide, which you both have addressed in your interventions, which is the principle gave the possibility for the parties to choose non-state law. So my question to you know, and I mean just to inspire the discussion. And you both have participated in the discussions that led to the approval of the HCCH principles during 2013 and 2015, right? We can imagine the challenges in drafting or negotiating this novel provision back then. So now that 5 years after the approval of the Hague principles, so we have now witnessed there some progress and in use or being referred to. So I'm very much interested in knowing your views, whether you saw any differences between the design of the provision back then and its current usage, the differences. I will also be very interested in hearing about, in your opinions, the prospects of the application of the non-state law and how and in which way the application of the non-state law and under the Hague Principles will or could further promote the CISG and the UNIDROIT Principles, whether in practice or in the literature that you are busy with. So now question to you. Thank you.
To you, to Neil?
And you. Or maybe now, no, you're here, you are not muted, so so maybe Joachim, you can go to share your thought on that.
First of all, I would like to mention that apart from the very interesting news, at least for me, absolutely not yet heard from his country in the context of the preparation of a new restatement on conflict of law. In addition to that, I'd like to mention the experience of Paraguay, because they have very soon after the adoption of the principles by the Hague Conference, adopted a law dealing with the applicable law in international commercial contracts. And in that statute, they have introduced, I think, literally also Article 3 of the Hague Principles. So this, I would say, represents a very interesting and important precedent, hopefully to be followed also very soon by other legislatures. The role of rules of law, well, here I take it, and Neil will certainly confirm, also Laura Gama, that this is a very, very complex subject. Let me just, as a kind of joke, tell you that one of the delegates of the members of the working group at The Hague one day approached me saying, Professor Bonell, you may have noticed that I strongly opposed to permitting parties, even only under our principles, to choose rules of law instead of a veritable law. But I, I got very much impressed by the vigor with which you defend your position, which is contrary to mine. I would like to give you an advice. You may follow it or not, but perhaps this could lead to a very interesting result. You are living in Rome. Rome, if I'm not mistaken, is not too far away from San Marino. And why aren't you not taking one day the car and go up to San Marino? You will certainly have some colleagues and friends there, and convince them to have San Marino ratified, so he expressed it, the UNIDROIT Principles as their law. At that point, I will be the first recommending the adoption of Article 3 also in our principles. Now, apart from joking, it is, whether we like it or not, still a prejudice, is it? And that law is only state law, and then you hear even more of this kind. It must be have a democratic legitimation. Its content must be fair and balanced. and with this I finish my intervention. Who on earth does, when faced with a request of choice of law in favor of the state law of Ruritania, which domestic court elsewhere makes the recognition and enforcement of such a contract dependent on the democratic legitimation of that law of Ruritania and on its fair and balanced content and similar things. No, because if it is the law of Ruritania, that's the end of the story, unless you can invoke ordre public, but this is admittedly in contract law matters fairly seldom. This is the paradox story of having rules of law adopted in the Hague Principles, which I am very much in favor, of course, but it was not an easy task, was it, Neil?
It was not an easy task at all. And Joachim, you've put your finger on some of the difficulties. In many ways, we talk about what we're looking for is legitimacy of rules, but for the traditional shortcut to concluding that legitimacy is there is to look at sovereignty. If the rules are the product of a sovereign state, then we act as though they not only do we act as though they have legitimacy, but we act as though that's the exclusive means by which legitimacy can be demonstrated. And as you've pointed out so well, that's not necessarily the case. I think that it's no accident that the idea of choosing to be governed by rules of law rather than state law has found more favor in the world of arbitration than in judicial forums. After all, judicial forums are in fact the product of the sovereign. And so it's not at all surprising that one product of the sovereign would guard the exclusive route to legitimacy being sovereignty, while arbitral panels are privately are private panels backed up by state law, but nonetheless they are not staffed by officers of the sovereign, and so I think they are a bit more amenable to expanding the set of legitimate rules to include products of organizations like UNCITRAL and UNIDROIT. And of course, UNCITRAL and UNIDROIT are organizations that are made up of member states. They are products of sovereigns, albeit indirectly. I think the extent to which Article 3 will gain influence over time depends a little bit on history. I think it'll be slow, and one of the reasons that it'll be slow is that the matter was debated as part of the debates that led to the Rome I regulation, and as many here know, the ultimate resolution was not to choose the route that Article 3 of the HCCH Principles chooses. There's also typically a reluctance on the part of states, as in part of people, to be first. Once a trend is started, states are willing to join, but lawyers are usually taught to be the second person to do something, not to be the first person to do something because of our reliance on precedent. And so the fact that Paraguay has already adopted this as a matter of its law, the other states may follow. Perhaps the non-binding but influential restatements in the U.S. Will endorse the idea. Perhaps it will, in fact, gather steam, but I think it'll be a slower process. We already have a big foothold in the world of arbitration, but judicial forums, I think, will come along slowly.
Thank you very much, both to you and Joachim and Neil for your insightful and valuable thoughts on the use and the future of the Article 3 of the HCCH Principles. Yeah, indeed, we heard from today, we saw we are seeing the development both in the judicial sector and the arbitration side. Of course, there are much more development from the arbitration centers, like the Permanent Bureau, and it's also working towards to, together with the arbitration center, to promote the use of the state, the making reference and the use of the HCCH principles, including the use of the rules making reference to the CISG or UNIDROIT principles, or this non-state law rules as a whole. Okay, thank you. Now, actually, we are approaching to the end, the time slot for this panel. I will still give the one question from the floor if there's any. I saw there's one coming in. Okay, I read it out. So this question from Najib Rose. So the question is, what are the practical limits of the UNIDROIT principles, the HCCH principles, and the CISG? Probably I will first give the floor to Stefan.
I feel that I'm probably the least qualified of the panel to speak on this. Of course, the practical drawbacks have been mentioned in a way that, by no fault of their own, the CISG and particularly the UNIDROIT principles are disadvantaged because very often a practitioner will not advise their use as the governing law because the acknowledgement of such a choice in the state courts is implausible or improbable. I think I'd leave it there. Obviously, we could talk about details. I mean, they're all sorts of discussions about where the CISG is perhaps a little bit too buyer-friendly or a little bit too seller-friendly, and there are discussions as to the adequacy of individual rules in any of these instruments. But I think that would be a topic for a separate symposium. Thank you.
Thank you very much, Stefan. I wonder whether Neil or Joachim, would you like to add a word?
I think a point that Joachim made earlier is very important here about the provincialism of many lawyers providing a practical impediment to the further use and development of these instruments. And in an ideal world, attorneys would know the various rule sets that are available to govern a particular transaction and advocate for the one that benefits their client and settle for one that's somewhat, that is agreeable to all sides, meaning it's somewhat neutral. But typically that's not the way lawyers approach transactions. Instead, they tend to start either from a viewpoint of local pride, my law is best, so I must advocate for my law, or from a position of fear. Those other rules that I haven't mastered must be worse, and they may have traps of which I'm unaware. So I will resist application of them. And so long as attorneys apply those approaches as opposed to looking at the nature of the rules, the quality and completeness of the rules, and how those rules affect their clients, I think there will be a practical limitation that comes from this fear. As all know, the CISG allows people to opt out from application of the CISG, and a significant number of contracts, the number is going down, but still a significant number of contracts, parties opt out. And I suspect that most of the time it's not because the rules are worse by agreement. It's simply because the parties do not want to grapple with the possibility of rules that are novel to them and may be different than the ones to which they're accustomed. Until we break through that, and the progress has been slow, but it has been progress, I think that's a limitation on just how much influence in particular transactions these international instruments will have.
Thank you, Neil.
May I add one word?
Yes, please.
Yeah, very, very briefly. No regard as a rule to the content of the chosen law. If it is different from my own national law, better say the national law of my lawyer. What I would like to ask my two fellow panelists is whether in their view, the choice of a so-called neutral law or a law of a third country does not imply the risk that individual terms of the contract my client has concluded turn out to be incompatible with mandatory rules and principles, doctrines of that chosen foreign law. And the examples of such a possibility are, I would say, endless. Isn't that an aspect which we should also flag out, warn parties and their lawyers? Look, perhaps the choice of, now I do not want to make names, give names, but we know who are the favorites on the international scene, for the better or the worse. But if you then come down to a concrete case dispute, what about the extrinsic evidence for the interpretation of our written contract drafted according to well-founded, for us at least, principles of Italian law? I personally, even personally, in some few cases, made this experience that, oh yes, this is such a smart, sexy choice we made. But then it comes down, can we invoke extrinsic evidence in order to interpret our contract properly? According to Italian law, of course you can. According to that foreign chosen law, absolutely no possibility to invoke such extrinsic evidence. Now, this is a risk which too should be borne in mind if one insists on the necessity of choosing a particular domestic law.
Well, Joachim, I can't imagine which state you might have been subtly referring to in terms of not being able to introduce extrinsic evidence, but that's a great example of the need of parties and their attorneys to understand the nature of their choice. It's not just about preferring the state in which they're educated and whose law they know, but understanding the impact of the legal rules. There are arguments to be made both ways on the very good example you just gave about extrinsic evidence, but parties need to be aware that insisting on their domestic law or incorporating the UNIDROIT principles or choosing the UNIDROIT principles as rules of law is not only a statement about neutrality and a statement about the high quality of drafting, it's a statement for a certain set of rules. And it may be that pushing for their own domestic law because of their familiarity with it may have the effect of preventing them from doing something that would be very useful in the circumstances, such as demonstrating the meaning of an agreement by the use of extrinsic evidence. If parties don't understand that that it's not just the label given to the law of the United States or the law of Italy or the UNIDROIT principles, but in fact it's a rule set, then they'll make inadequate choices. And what we need to do is to help people understand, I think, the fact that the choice of the UNIDROIT principles or the CISG or any national law is not simply about national pride or about comfort level. It's about the substantive consequences of that choice.
Thank you. Thank you for the question and answers. It's very inspiring. I see we have two more questions coming up. There's also a question to all panelists. I saw the Professor Ning Zhao is also answering. And those are very interesting questions. Unfortunately, the time slot allocated to this panel is ending. So with regret, I have to, also the pain in my heart, I have to close this panel for now. But we would note down these questions, and we hope there's a possibility we can either exchange the answers offline, or maybe let's see whether at the end of this conference we will still have time to address them. Okay, thank you so much. Thank you to the co-panelists, and happy to have you on board. And thanks to all the participants and to the Secretariat of UNIDROIT for organizing this conference. Thank you for now. Now I give floor
Excellent
back.
chairmanship, Madam Chair.
Thank you so much, Joachim. Thank you for the cooperation.
Thank you, Ning. Now we take a short break. We try to reduce it to 10 minutes because we are a bit late. So we will resume instead of 2:45, it's gonna be 2:55. We try to make it before 3, so we don't add delay to the one we already have. Thank you.